Now, let's review labor laws that apply in Korea. For the labor laws, a number of independent acts by subject, not in the form of an integrated code of laws, have been established based on Articles 32 and 33 of the Constitution of the Republic of Korea. The most representative labor laws are the Labor Standards Act that deals with the labor relationship between an employee and an employer, and the Trade Union and Labor Relations Adjustment Act that deals with the activities of a labor union. The Labor Standards Act and relevant laws and regulations clearly define the principles that should be followed with regard to the whole process of labor relationships, including their establishment, development, and termination, and penalties provided in the laws and regulations apply in cases of violation. In signing or altering an employment contract, an employer should issue a labor contract stating wages, work hours, holidays, annual paid leave, other terms and conditions of employment as prescribed by the enforcement decree to employees. If and when any of the terms and conditions of employment as expressly set forth are not observed, an employee may file a claim with the Labor Relations Commission and may terminate the labor contract. The work hours for an employee should not exceed 40 hours per week and 8 hours a day. These work hours are called the statutory work hours. Where agreement is reached between the parties to a labor contract, work hours may be extended by up to 12 hours per week. This means that work hours up to 52 hours per week are possible. The provision regarding work hours does not apply to employees working in certain businesses. With an employee working in the industries of agriculture and fisheries, a watch worker such as a security guard, etc., in the event of a reason prescribed by law, such as a disaster, special extended work which exceeds 12 hours per week is possible with the consent of employees and the authorization of the Minister of Employment and Labor. In addition, there are flexible work hours systems and selective work hours systems that adjust the average work hours so as not to exceed 40 hours a week, even if an employee works more than the statutory work hours in a particular week or day through written agreement with the employer. An employer should guarantee employees at least one paid holiday per week on average, as well as paid annual holidays. Every employer should grant any employee who has worked not less than 80% of 1 year a paid leave of 15 days, and 1 day for every 2 continuously working years should be added if the employee has actually worked continuously. In this case, the total number of paid leave days should not exceed 25 days per year. Any employee who has continuously worked for less than 1 year is granted 1 paid leave day for each month which he or she has continuously worked. A minimum wage system is in force in Korea. The Minister of Employment and Labor determines and announces the minimum wage by August of every year by reflecting the minimum wage deliberated on and decided by the Minimum Wage Commission, and the announced minimum wage enters into force for 1 year, starting from the year following the announcement. The 2020 hourly minimum wage in Korea is 8,590 Korean won. The Korean government wholly amended the Occupational Safety and Health Act in 2018, and the amended act has been in effect since 2020. With the amended act extending the subject of protection from employees to workers. The Occupational Safety and Health Act imposes the primary duties of safety and health management for a place of business on employers, supports and supervises them in the proper performance of their duties, and provides safety and health technical guidance and financial support to small and medium enterprises by establishing the Korea Occupational Safety and Health Agency. The purpose of the Industrial Accident Compensation Insurance Act is to ensure that workers are compensated promptly and fairly for any occupational accident, and that the rehabilitation of employees suffering from occupational accidents and their return to society is facilitated. To achieve said purposes, the Korea Workers' Compensation and Welfare Service has been established and is operating, and the Industrial Accident Compensation Insurance and Prevention Fund is financed using insurance premiums paid monthly by employers. A disciplinary measure is a sanction in response to a violation of employees' rules or order at work by an employee, and such disciplinary measures include warning, demotion, suspension, dismissal, etc. The Labor Standards Act prohibits a disciplinary measure without justifiable cause, and the justification of a disciplinary measure is assessed by reviewing the grounds for a disciplinary measure taken, the degree of the disciplinary measure, and the relevant procedural compliance. An employee who has terminated a labor relationship may receive retirement benefits as well as unemployment benefits. According to the Act on the Guarantee of Employees' Retirement Benefits, an employee can make a claim against an employer for retirement benefits at the time of retirement, regardless of the cause of the termination of their labor relationship. And the employer should provide such retirement benefits through the relevant retirement pension plan or retirement benefit scheme. Also, the unemployment benefit is a system designed to help employees suffering from financial difficulties as a result of unemployment and supports them in opportunities for re-employment. Details are provided in the Employment Insurance Act. An employee who satisfies the following eligibility requirements for receipt of such benefits receives the unemployment benefit of up to 66 Korean won per day for no longer than 240 days. The financial resources for the payment of unemployment benefits are accumulated through employers' and employees' payment of monthly insurance premiums. The scope of workers who are free to establish or join and participate in a trade union in Korea includes any person who lives on an income equivalent to wages, in addition to any person who lives on wages or salary, and it is wider than that of employees as defined in the Labor Standards Act. A worker can establish a trade union by submitting the establishment registration documentation to an administrative agency and receiving a related registration document. A trade union can be established by a company, as well as by industry or regions beyond the scope of any company. 2 confederations of trade unions exist in Korea. The Trade Union and Labor Relations Adjustment Act guarantees 3 labor rights, including the rights of association, collective bargaining, and collective action under the Constitution of the Republic of Korea. If collective bargaining is not carried out smoothly and fairly, the relevant labor union may file an application for mediation of a labor dispute with the Regional Labor Relations Commission, and the Regional Labor Relations Commission shall organize a mediation committee and promote negotiation between the labor union and the employer. When the relevant adjustment procedures have been completed, the labor union may call a vote of union members for and/or against proposed industrial action. Any subsequent industrial action may be undertaken legally only when such an action has been determined and endorsed with the formal consent of a majority of members. Meanwhile, the Trade Union and Labor Relations Adjustment Act specifies public service businesses as follows and requires relevant public service businesses to operate essential business at all times, even if industrial action is taken. The labor inspection system was introduced when the Labor Standards Act was established in 1953. Each local employment and labor office operates a labor inspection department and industrial safety inspection department separately. The labor inspector system is an administrative inspection system implemented to guarantee the effectiveness of labor laws. Approximately 3,000 labor inspectors are in the Ministry of Employment and Labor, so that when a case is received by an employment and labor office, labor inspectors commence an investigation into the employer and worker with full investigatory authority. Occupational safety and health inspection is conducted by occupational safety and health inspectors who have the status of labor inspectors. The inspection business can be classified into ordinary workplace inspections and on-site accident investigations that are carried out in the event of significant disasters. If and when any violation of laws by an employer is found, it is handled accordingly to the provisions of the Occupational Safety and Health Act. The Labor Relations Commission is a representative administrative agency that settles labor disputes. It consists of the National Labor Relations Commission and 13 regional labor relations commissions and handles the following business. With regard to the Industrial Accident Compensation Insurance benefit, it is handled by a branch of the Korea Workers' Compensation and Welfare Service, and approvals are determined by the Occupational Disease Adjudication Committee. Any person who has an objection regarding a decision may file a request for review by the Industrial Accident Compensation Insurance Examination Committee or the Industrial Accident Compensation Insurance Reexamination Committee. Any employee who has an objection regarding unemployment benefits may file a request for review by the Employment Insurance Examiner. Any employee who protests against a decision made by the Employment Insurance Examiner may file a request for further review by the Employment Insurance Appeal Committee. Also, in each of the above cases, any employee who protests against a final decision may file administrative litigation with the relevant court. The judicial process in Korea operates generally through a 3-level court system, including the District Court, High Court, and Supreme Court, with litigation related to labor disputes classified into civil litigation, administrative litigation, and criminal litigation. Typical civil actions filed by an employee may include an action filed when an employer fails to make a wage payment, or an action filed seeking invalidity in relation to unfair disciplinary action, such as unfair dismissal. Administrative litigation is the appeal procedure related to dissatisfaction regarding a judgment made by various administrative agencies attached to the Ministry of Employment and Labor, and it is filed with the administration of a regional court or the sole administrative court. Most criminal actions hold an executive of a labor union criminally liable for an illegal industrial action. Also, beside those courts, the Constitutional Court, the main purpose of which is to guarantee the fundamental rights of citizens, has been established, and constitutional litigation may also be filed if an article in the labor laws is seen to violate the fundamental rights of employees. As society has changed, additional acts and provisions have been established in relation to the labor laws of Korea in order to solve various issues, including gender equality in employment, work and family life reconciliation, the abolition of discrimination between full-time positions and temporary positions, bullying and sexual harassment in the workplace, etc. Demands for the amendment of the labor laws are being raised again, along with significant changes as a result of the Fourth Industrial Revolution and COVID-19. That's a wrap on the labor laws of Korea. KLAW Academy.